Parties can contract to do almost anything except things that are illegal. In Clouse versus Myers, we'll explore whether parties harmed by their own illegal agreement can get help from courts to redress the wrong. Patricia Myers operated the Green Door Tavern. Myers had a sole owner beer by the drink license issued in her name and personally leased the premises from John Hearn. Patricia's husband, Jerry Myers, asked one of the bar's patrons, J. Todd Clouse, if he'd purchase an interest in the business. Thereafter, the Myerses signed a contract with Clouse. The agreement referred to the parties as employers and employee. The agreement provided that the Myerses would operate the bar pursuant to a 4-year lease with Hearn, which had a purchase option. The Myerses would hire Clouse as a manager for 4 years with a salary based on 60% of the business's net profit, and Clouse would pay the Myerses $15,000 with $7,500 due at signing. In return, Clouse would receive a 60% ownership interest in Green Door either at the termination of the agreement or when the Myerses exercised their right to purchase the premises under the lease, whichever came first. If the Myerses chose to purchase the premises from Hearn, the Myerses and Clouse would each cover half the price. The contract also provided that if the Myerses did anything that directly resulted in the loss of the bar's liquor license, any money paid by Clouse to Myers would be refunded. Clouse paid Patricia $7,500 and began operating the tavern. 2 weeks later, Clouse and the Myerses were called to meet with the Missouri Division of Liquor Control at the police station. Because Patricia had failed to obtain a new partnership liquor license with Clouse, and because Jerry, who was a convicted felon, had participated as an owner in the contract, Liquor Control urged Patricia to voluntarily return her liquor license. Patricia complied. Clouse demanded the Myerses return his $7,500, claiming that he was induced to enter the contract by the false representation that Jerry was a partner in the business and that the bar lost the liquor license as a direct result of the misrepresentations in breach of their contract. When the Myerses refused, Clouse sued the Myerses for misrepresentation and breach of contract in a Missouri state trial court. The Myerses counterclaimed for the other $7,500. At trial, Clouse admitted that he knew the license was only in Patricia's name and that the reason the contract was labeled as an employment/management contract rather than a partnership agreement was so the bar could be operated under Patricia's license. The trial judge ruled for Clouse. The Myerses appealed to the Missouri Court of Appeals.